All right. So good morning. Happy Friday. Happy Friday. Happy March 20th. Man, oh man, the month is going so quick. Again, for the people that do not know who I am, my name is Simon Cazares. I am the team leader for the Torrance, KW South Bay, and I'm also the broker for multiple offices, the Torrance, the Long Beach, and the two satellite office, the main office and the satellite office in the Valley as well. For people that know me, I've been in the industry for just shy of 30 years in this industry. So I think I know a thing or two. And the beautiful thing is I know what real estate can definitely provide to us as licensed real estate professionals, but more so the impact that you'll have for your buyers and your sellers and your investors. Well, today we're going to be talking about probate, okay? The complexity of probate. Well, it depends on who you speak with, right? Some will say, oh my God, probate, it's very complex. Well, it is. Technically, it really is complex, but this is the reason you hire attorneys. Attorneys are the ones that handle the ins and outs with the court system. Our job is very simple, okay, is to sell properties. That's it. Or if we're going to be representing a buyer who's interested in submitting an offer on a probate, then there's additional requirements, paperwork that needs to be included as part of the process. So we'll go through the channels. Now, as a disclaimer, ladies and gentlemen, I am not an attorney, okay? I'm not claiming to be an attorney. I'm here as educational purposes. Obviously, if there's any technical questions, we can always redirect it to an attorney that practices probate, okay? So without further ado, let's go ahead and continue. So the probate real property sales in California. So it's really kind of a Q&A type. It's surface conversations, okay? We're not going to go too deep and too technical, but I want you to kind of understand if you do end up picking up a potential probate. Now, what is probate, right? Because I get that question asked a lot is what is probate, right? Well, it's when a property passes away, doesn't have a will, doesn't have a trust, and now we don't have any direction of what needs to be taken care of. Real estate, debt, taxes, obligations, responsibility. This is why it's important. If you have assets, is critical and important to do a trust or a living trust or some type of will, right? Because that gives you kind of instructions after your passing, right? It's a good thing. It's not a bad thing to prepare for, difficult circumstances that your family, your loved ones will be in the burden to, handle. But if you've been pretty efficient when you were alive and had everything all taken care of, it's just like opening up a book and saying, okay, here are the instructions that I'm wishing as part of my decision, now that I've passed, right? So let's get into the meats and potatoes of today's topic. We'll go into the forms that are utilized as part of it, the purchase agreement, the listing agreement, the advisories, and also the addendums as well. So most of it is going to be the table of content that we're going to be talking about, the probate procedure in general, the listing contracts and disclosures, how commissions also work when it comes to listing property or submitting an offer, and then the initial offers and overbids as well, and then obviously the IAEA documentation or authority to submit. So probate proceedings in general, right? As I mentioned, no one wants to be in this situation, but sometimes people just suddenly pass away and never created a living trust or some type of will, right? And now the family has the pressure and the burden. You cannot just continue doing the way things are when someone is no longer there, right? Especially real estate, right? Well, now that my parents have passed away, or my mom passed away, my father passed away, we want to sell the property. Well, you don't have the authority, right? Especially if there was no trust involved. And people think, well, it should be easy. I'm family. This was my parents' house. Well, the state of California doesn't see it that way. And this is why there has to be a chain of process. And obviously, you want to get legal advice and what the next steps are. But it's more so, it's just kind of the understanding of the framework, right? Of how personal representation, the role that it takes, right? You're basically going in as the role and authorized individual to be able to navigate the financial perspective of the deceased, right? And more so if there's real estate involved. Okay. And it may be where there's multiple properties too. It's not just one property, it can be multiple properties too, as well. So, this is why it's always best that we have those conversations with our parents, our siblings, right, family, and the importance of having a trust, right, because it'll give more clarity, it'll give more understanding that it'll be easier when we have to go through the motions of an unforeseen circumstances, right, when it comes to death. So how does probate work during a sale, right? The personal representation. This is the person that has been appointed or has the right to navigate, the real estate. The personal representative either is an executor named in the will or is appointed by the court, right? So you can be someone as a family member or even a friend. Okay. It doesn't have to be related, it doesn't have to even be blood. Someone can step in and in the capacity, right? The capacity to help navigate the initial process when it comes to selling real estate. The authority is a granted by the courts. Okay, so it is granted by the courts. So navigating this, right, is obviously number one, hire a probate attorney, right? Someone that does this on a regular basis, because not all attorneys specialize in probate cases. It can be as simple or it could be as complex, right? But having the right attorney that knows the ins and outs and ultimately get it to court confirmation, then it allows us as licensed real estate agents to represent the executor on behalf of the estate to be able to sell the real estate. And that's all we're doing. Okay. We're not doing anything else but selling real estate. We have the license and authorizations by the state of California to do so, right? But know the ins and outs. Now, the beautiful thing about these type of transaction is no difference than what we talk about on a regular basis. We need to be out there prospecting, connecting with buyers and sellers, investors and developers, right? But there's also a different type of niche too. Speaking with attorneys, speaking with probate. And there is a list of probate attorneys out there that we as real estate professionals should be at least tapping into it and having dialogue and conversation, right? Maybe send a letter with your bio that you'd like to connect and ultimately be that next resource when it comes to representation, right? Because they have a big um, portion of involvement when it comes to the initial process, right? In attorneys, even though most of it would be kind of similar where a seller can pick and choose or at least interview three different licensed agents, right? So the court will probably have that same process is even though you are appointed or at least you believe you're appointed to represent the estate, it still needs to be it still needs to go through the actual court system, right? And the court may say, look, yes, we'll sign off and we'll grant, Simon, as an example, the authority to sell the property. Or the court may say, we must get three qualified real estate professionals who have been in the industry for a minimum of 2 to 3 years with the production of, and it can be that technical. And now we have to find and identify real estate agents that meet the minimum qualification. And then that goes through the motions of interviewing, right? And submitting our bio. And then the court at the end will review the three different real estate companies, and it could be three different brokerages. It can be Keller Williams, it could be Century 21, it could be Remax, right? And all of them have different types of experiences, right, in production. And then that gets handed over to the courts, and then the courts will approve and seal. Well, this is the individual agent that will be representing the estate of this property. Okay, does that kind of make sense? Okay.
Simon, just a quick question on that. Who
Yes.
chooses the agents again? The
Say
court?
again.
Who chooses the agents to represent the state again?
So it really depends on the circumstances. Usually, it's the executor of the estate may have the biggest influence. So let's say, for example, right, I'm a son of my deceased parents, right? And my parents never had a trust or a will, right? And now, we have real estate assets, debt, obligations that need to be taken care of, but I'm not able to because they're no longer here, right? So then I hire an attorney, right? And I go through the motions of explaining the situation to the attorney, saying, hey, here's the situation. We have real estate we need to figure out. We have taxes that we need to pay. We have obligations, but I don't have any authority to do so because no one will give me the opportunity to do so because I don't have any written instructions. I don't have a trust or a will that says that I will be able to, on behalf of the estate, be able to represent, right? Because once you get the approval, it's basically you're stepping in as a substitute. You're basically stepping in the responsibility to take care of the obligations, right? Selling real estate, paying off debt, right? And the court may step in, 100% of the time, 80% of the time, depending on the situation, right? If it's a child, as an example, we know most of the financial situation, right? It may be easier where the court will grant us the opportunity to navigate that because we we're attached from our parents, right? But sometimes it may be someone else that is handling the probate, right? It may be a friend, it may be a neighbor. I've seen circumstances where the neighbor, had a very close tie, but the deceased never had or was not connected or has no longer family, right? And now you have an asset there, and we kind of step in. There's a procedure and a process that needs to go, but ultimately the court will make the decision and who they end up picking, right? Or the person that's handling or starts the initial process. So, for example, if going back to the scenario, I can then, as part of the court, they say, well, Simon, you gotta interview three different real estate professionals and then provide me with all of their bios and what they believe the property is worth, right? Then I go and start interviewing three different real estate agents, right? And then part of the initial process is, hey, I'm going to need your bio because I need to submit it to, the courts. And then ultimately, once that information is provided, the courts will either give me the permission to pick and choose who I believe would be the best fit to sell the property, or they may give me a direction that this is the most qualified real estate agent to do so, right? So it's one of those things. Just because you have that connection doesn't necessarily mean that you may be the appointed real estate agent to represent the estate on behalf of selling that real estate or multiple real estate, right? Just because you have that connection. The only avenue is because this is a very different, unique circumstances, right? Because the person that was on title is no longer able to do anything because they're passed away. This is the reason we have to go through the initial process with the court. I hope that kind of answers your question.
Thank
So
you.
the
Yes.
personal representative is either an executor named in the will or the court-appointed administrator is in charge with gathering the assets, paying debts, and distributing the real estate to the heirs. Okay. Their Authority is granted through the letters, which is a jurisdictional council form. Most businesses deal and run through the state attorney. So again, the pros and cons, most if not all the time, the attorney handles the initial process when it comes to this. Okay, one second. Let me omit a
Just one
couple.
question. We're not seeing a slideshow. We're just seeing the first page with a house on it. Is that what you're showing?
Now, one second.
Thank you.
Thank you. Okay, can you see it now?
Yes. Thank you.
Okay, thank you. All right, well, let's go ahead and continue. When may an estate property be sold? Okay, when there's debt and expenses. Sales are typically necessary to pay debt, family allowance, estate administrator expenses, and taxes, right? So that's when, the initial process. And in many cases, you may not have to, sell the estate, right? Because maybe the person that was deceased took care of all of the obligations, right? And prepared everything in the right, but unfortunately failed to do a living trust or a will, but everything else was all taken care of, right? So the essence is they may not be in a position where they have to sell the real estate, right? But most cases, in my personal experience, typically you will end up selling the assets to pay off all of the obligations. What are the estate benefits? Sale is to the advantage of the estate is the best interest of the interest persons, right? Because they may need to pay, the obligations of the deceased, right? There might be a lot of debt involved, right? And the debt has to be paid, even though you may think I am the son or daughter of the deceased, doesn't necessarily mean that the proceeds will go directly to you. No, the deceased might have had a lot of debt which needs to be taken care of first. Anything after that, then it may be considered as part of your errors, right? Part of your reward per se, right? Will direct sales. The property must be sold accordingly to the terms of the will or the will authorized of the sale, right? The whole purpose of a living trust and a will is directions, right? Directions of what the deceased has put upon, why they were alive, right? And it can be a very specific. One movie that I can think of, it's an old classic movie from the early 80s. It's called Brewster's Million. Brewster's Million. And I think about that movie is because it goes into a little bit about, someone that allowed them an opportunity, right? If you have not seen the movie Brewster's Million, the classic with Richard Pryor, I recommend you watch it. It's funny, hilarious, but it's like, man, how cool is it? I'm not going to spoil it, but it has a nice little twist to it, and I recommend. I know they made a remake of it, but you need to watch the original Brewster's Million. You'll get a kick out of it.
Does it talk about wills and trusts? Is that what it does, or probate?
It definitely talks about wealth. It does talk about the initial instructions that the deceased has given, but it doesn't go into the technical aspects of what we're talking about. It's more of a funny movie, but it portrays someone in a position that wasn't even aware that they were going to get all of this money. But it has a little bit of a twist where they have to basically expend an enormous amount of money within a 30-day period. And if they do, then they would get even more money. And if they don't, that's it. They lose everything. So it's a classic movie, but it doesn't go into the depths of probate. It's just more about the initial process that anyone can will you anything, right? You don't have to be family in order for you to receive something from someone that has passed on. Maybe you were a great neighbor and they saw good in you And part of their will or their trust says that, after my passing, please provide them with this. And it might be something of significant, right? Maybe it was a watch, maybe it was jewelry, maybe it was monetary, maybe it was a vehicle. Heck, I've even seen real estate being part of it as well. Sometimes the deceased may um, give the estate to a charity. I've seen that to colleges and universities as well as part of their process of giving back. Key restrictions on price and confirmations. So, this is what we call the 90% rule. Private sale must be at least 90% of the appraised value. Okay. And Mark, correct me if I'm wrong, but I'm assuming that you probably have been involved with probate type of sales. Is that pretty accurate to say?
Yeah, we I mostly do estate appraisals after one of the spouse has died and they want to establish a new step up basis. But I got a call just a month ago. The family had everything in trust, living trust, except the mother died, let's say in June, and her everything went to the father. Well, the father was 95. He died 6 months later, and because and he was the intended trustee
Mm-hmm.
because she had an old 401k, an old trade account where he was the trustee. TD Ameritrade says, well, the trustee's dead. We don't have a trustee. It has to go to probate. So everything else was taken care of in the trust, except for this one little account that named the husband, who was now dead, and there was no assigned trustee. So the family is battling with the court to say, hey, look, we took care of this except for this one thing, and now they got to go through probate. And
Yeah,
the cost of the attorney and the filings and whatnot is probably going to deplete the account, but
right.
it's holding everything up. So that's kind of
Yeah,
my experience with probate.
got it. Thank you for sharing.
Yeah.
Yeah, we never want to go through a probate because it's very expensive. Attorneys will, unfortunately, uh, attach themselves as much and prolong the process because the longer the probate process, the more money they make. So this is the reason we encourage people, get a trust, set it up, while you're still alive, because the headache and heartache that you'll leave your family behind it's not easy. And if you don't know, then you're exposing, all of the hard work and devotion that your family, your parents have put. But a lot of people unfortunately just don't know. We were not educated, right, on what we should be doing, right? And as real estate professionals, those are some of the conversations you should be having with people, even though they may not be in the position to sell. But how many people don't have trust? There's a lot of people that don't have trust. And I'll give you an example. My parents for the longest time didn't have a trust. And it wasn't until maybe 5 years ago, I just put the hammer down and I says, look, you know what? It's a difficult conversation to have. No one wants to talk about death. And I get it, it's a difficult conversation to have with our parents, right? Because we want our parents to live forever and ever and ever. But the truth of the matter, that's never the case, right? We're here today, we may not be here tomorrow, right? So it's vital and important for all of us to, just have those conversations, especially for our parents, right, as they get older. And yeah, I mean, I had to sit them down. I had to anchor that conversation is because one, they didn't know. Okay. They thought, hey, I'm just going to give it to you, right? Or give it to the children, right? Or we'll do what do they call transfer of title, right? We'll just grant it, we'll quick, it doesn't benefit you from that, right? So the best layer of protection is always to do a trust, right? Because the benefit of that is the step value, right? And for tax purposes as well. So there's benefits to it because my parents have owned the property for almost 30 years now, maybe 32 years, right? Early 90s, right? So imagine what the property taxes are from that time to the property taxes now if we were to do anything with it, right? So, uh, but it took them all this time to do so. And it wasn't something that I've been encouraging them to do for a very long time, but they put it aside. But it was one of the family members that said, maybe you should consider. And then that's where the conversation started. But that just tells you uh, that people just do not understand the importance of having a trust, in my opinion, right? And it's vital, even
Simon,
for your own personal stuff as well. Yes.
I have two questions. I have, if you don't mind, can I ask a question to
Yes.
Mark? I have a question to Mark because I'm wondering if TD Ameritrade can allow beneficiary or beneficiary to do it while that person's alive, or whatever they call it, trustee or beneficiary, or that has to be in a trust.
So my understanding is if they had named additional beneficiaries and trustee
Okay.
on that account, it would have been fine.
I see. Sure.
So
Sure.
they just,
When that person's alive.
I've done the same thing. I've got trade accounts that I've got my wife as the Benny. Well,
Okay. I
that's
have an
it.
account too. That's what I'm asking.
Yeah,
Thank
yeah,
you.
make
Makes
two.
sense. It's a good idea. And also, Simon, this question is for you.
Uh-huh.
When I close a deal, I wanted to ask you, is it best to advise our clients to put the property in a trust in escrow or after they close escrow?
Repeat the question one more time.
I always recommend my clients to put the property that I'm selling in a trust. So if they don't have a trust yet and they're just buying this property now, do you recommend that we do it after we close escrow or during escrow?
Yeah, I mean, it depends on the situation, right? If they're buying a property, right after they close, they can always speak with a trust attorney, right? That will set them up for that. Thank you so much. I appreciate it. That would set them up for, with the trust, because what happens is they take it out of your personal name, right? And they put it into your trust, which kind of gives you kind of a layer of protection too, as well, that it's not under my name. I don't own the property, the estate or the trust owns it, right? So for instance, if you are representing the buyer on a purchase, one of the conversations you should have is, you know, how you're setting yourself, right, for any future issues, right? And a lot of agents don't have that conversation. But imagine if you had that as part of the checklist, right? After you close the deal, maybe you have recommendations and says, look, it would be to your benefit to speak with a trust attorney to see what next step is to protect you, right? Because you never know. You could be a 30-year-old young family, right? And something may happen. And because you think, well, that I need to worry when I'm in my 80s, right? Well, no, right? Because it can impact any of us at any given time. So having those conversations from the very beginning as that resources and says, look, I would recommend that you at least speak with a trust attorney to give you what the next steps would be to protect yourself and your family for unforeseen circumstances, right? Which is the big elephant in the room, right? Death. But at least they have that all set up, right? Because it gives instructions, right? Because, and I can see this happening in circumstances, and I'm going to go deep into this because I think it's very important.
Simon,
When yes.
one phrase I use a lot when talking to people about trust is let's look at the worst case scenario from the perspective of the bank. and that kind of takes it out to a third party and saying, hey, look, if something happens, you die or you go into foreclosure or whatever, what's the bank perspective going to be? And that
Right.
makes it a little less personal or a little less threatening.
Yeah. Yeah, exactly. 100%. Thank you for sharing. But yeah, it's important, it's really, really important to educate our clients because a lot of people don't think of what happens after, right? And it could be a young family, right? But the instructions and where I was going with this is this. Um, an existing family, right? Husband and wife. Husband and wife have two or three kids, right? Husband and wife have a beautiful marriage for 20 years. Husband and wife separate. Husband and wife divorce. Now the ex-husband now finds a new person. The ex-wife also finds a new person. They end up getting married, right? And now they have their kids as well, right? But they start buying real estate, right? So you can kind of see where this can be kind of a situation when they pass away, what happens to all of the real estate that was accumulated throughout the years. More so when a family member comes into the relationship, right? Uh, as an example, mom divorces father. Mom has multiple real estate, but decides to get married with someone new, right? So the protection of that trust protects, the instructions if something happens, because technically speaking, if they get married, it becomes community property, right? And that person's intent may be in a bad direction, right? Where they have control of everything, and it leaves out the legacy and all of the stuff that your mom has built for the purpose of your children, right? So this is the reason you want to have these layers of protection to protect assets and all that. It gives just basic instructions of what the next after my passing, right? No difference than um, another elephant in the room when it comes to prenups. Okay, prenups. People don't like hearing prenups, but you know what? Prenups are good because when it's a separation and a divorce in the making, you've already laid out the instructions of what's going to happen, so there is no fighting involved. When there is no prenup, that's when the cat and dog comes out of people, and this is what prolongs the process, and people get even worse and upset about it. But we could have eliminated that on a prenup, right? Because now I know that you're getting this, we're going to split this is how we're going to handle this, and more so when it comes to children as well. And especially in the early stages when there's separation, when they're still small kids. So again, people will agree with me or disagree with me, and I'm okay with it. I'm just laying it out, the importance of having these type of agreements. Now, for us as real estate agents, all day long, we'd love to have a list of, probate opportunities. 100%. Yes. Yeah. Of course. Yeah. Yeah. Yes. Well, it varies. I'm not going to go into, what it costs because every attorney represents differently and they charge differently. So, but on average, I've seen anywhere between $1,500 to $5,000, to set it all up from you from beginning to end, submit the proper documentations, submit the new deed of trust into the county recorders and all that. So, but it varies depending on how technical it is or how many assets in real estate will determine the actual cost.
So the year even after that everything is set up, the maintenance every year you have to pay.
Well, they encourage you because life changes, right? So they always encourage you, look into your estate, look at because things happen, right? This real estate got sold, that real estate you inquire, this is a new debt and all that. So they would encourage you to consistently just update your agreements, right? Because maybe one of your children's who was the appointed successor to that trust now pisses you off, and now you want to put your daughter, which allows you to do so because circumstances happen that way, right? Or what if unforeseen circumstances where your son passes away or your daughter passes away, right? This is why you have to have concise, updated information because it changes on a regular basis. Um, but to answer your question, yeah, absolutely. Does it necessarily have to be where you're communicating with the attorney? Well, yeah, I would say that maybe every year or every other year, maybe have a consultation with the attorney that actually started the trust and just see, hey, is there anything that we need to add or implement? There's advisories that you can put into it and instructions as well. With the laws that are changing on a frequent basis, you want that additional layer of protection because what if there's a loophole in your trust and now you think you have the authority to do so, but because you did this trust 20, 30 years ago and you didn't add this disclaimer or information into the trust, that can be a big factor where additional costs would be involved, right? So again, going back, I'm not here as an attorney, but I'm just giving you my perspective of what can happen, right? And more so, we'll definitely have a probate attorney to come and talk to us as well to give us the ins and outs of how all of this works. Okay.
Hey, Simon,
Yes.
can I make a comment? This is Alon from the Philadelphia
Hello. What's
Luxury
up, my
Office.
brother?
How
Yes,
are you,
sir.
my
Thank
good
you.
man? Thanks
I'm
for your
well. Thank
class.
you.
I love it. Always very good information. Regarding,
Yes, sir.
I heard your story about living trust, and oddly enough, I had the same thing with my parents. So I had no clue what living trust is. Turns out even my brother didn't know. So in other words, make a long story short, we had all three of us go to the same attorney, get living trusts in the span of 6 months. So that's covered. One of the main issues that people don't understand is that when somebody receives long-term care benefits, say like
That's
nursing
right.
home care, like from Medi-Cal, per se, they can actually later on come after the property and seek reimbursement after the death of that person. And by
Right.
deeding the trust into a living trust, that basically takes that out of the equation. So that's one of the main benefits of doing the living trust. Of course, to avoid probate. I mean, that's what the class is all about. But there are other main, other factors that might affect. So when I sit with my clients, I always bring that up. I always encourage them to go seek an attorney's advice and get living trust for different reasons. But this is huge. Medi-Cal is huge. So I just wanted to bring that up.
Thank you so much for bringing it up. I didn't even think about it, but you're so right about that. Yeah, especially as our parents get older, that's a layer of protection that a lot of people don't understand. That, once you start getting help from the government and they know that you have real estate, they may not immediately, tack it on, but after, the passing, they'll send a bailout saying, hey, you owe us $100,000 worth of care throughout the years for your parents. So it is so vital and important to have those, especially for older people, right? Because they don't know what they don't know. And I think it's very, very important to illustrate, just like Alon said right now, it's a protection, right? Because it takes your name, Simon Cazares, as an example, out of my name into now a trust. So now we can say to them, well, I don't own anything. We have a trust, and the trust is the one that owns it. So good point there, my friend. I really appreciate that. I think Christine, did you have a question?
Hi, Simon. I was just going to chime in with what Alon said, 100%. I told you this morning, SRAR had a probate trust Zoom call as well, which I did go on. I got some great slides. I shared one with you, but
Yeah,
I'll send some others ones to you. But that is
yeah,
100% true about the payback for Medi-Cal. So anything that you receive, any benefits. So for sure to be in a trust. I'm just going to make one comment. Everybody does their business, how they conduct their business, but I have always done that. I do not instruct my clients how to take title ever. And I have them, I tell them to seek a trust attorney or, any of the things that they want to do, because I never want to, put myself in jeopardy like that, saying one way or another. Even though we have these tools, I just feel like that's not my hat as a realtor. So I'm not telling them what to do with it. They ask me for
Of course.
options, then I would, say, but like tell them, here are your options, or talk to somebody else, because they can
Yeah,
do that,
exactly.
especially with the FinCEN
Right.
thing with uh entity buyers. So
Yeah. Thank you for sharing. Mark, what she says is the Southern Regional Association of Realtors. That's what it stands for. So hopefully that answers your question.
Thank you.
All right, let's continue. So the listing contract, what you need to know, okay? The listing period, an exclusive right to sell listing may not exceed 90 days from the original period, 90 days. And extensions are also limited to another 90-day increments and require prior court approval unless acting under the IAEA. An extension means, so what is the IAEA? It's Independent Administration of a State Act. That's what it means. So under that authority, the representative may grant a decision of the 90-day extension up to 270 days total. Okay. A proposal of action is required. What required addendums must we include? Well, the RLA, which is the Residential Listing Agreement, the CLA, the RLAA, and the RLAS. It's acceptable, but must have the probate listing addendum and advisory. If you go to your zip forms, you type in probate, it'll provide you different documentations for purchase agreement, and it's attached addendums, and also the listing agreement, which also includes an addendum regarding that this particular property is under a probate. Agency and TDS disclosure obligations, pretty self-explanatory, required for 1 to 4 residential unit. TDS are exempt, right? So seller of an estate real estate are exempt from the transfer disclosure statement. However, sellers must still disclose any material facts affecting the desirability. So as an example, right, parents pass away, there was no living trust. I'm now in the position to allow the authorization based on the court to sell the estate, right? And then I go through the motion. So I find whoever the listing agent is going to sell the property. Well, there are certain things that are exempt, right? So we don't have to do the transfer disclosure or the SPQ, the seller questionnaire disclosure, right? But because I know the history of the property, one, I was raised there, I know the history of it, it does not allow you to say silent. You still, as a protection, have to divulge and disclose that, because let's just say worst case scenario, you're exempt and you go with that motion and says, well, I don't have to say anything about the property. And later on, the buyer finds out something that I knew about, right? Because guess who's going to tell everything about the property is your neighbors, right? And the neighbors would say, well, yeah, the son lived here, and they knew about the issue with the roof, the plumbing, or any of that, right? One of the things that always sticks in my head is, as a kid, I was a teenager at the time. We had a lot of pets, and in the backyard, unfortunately, it's a pet cemetery. Full disclosure, there's probably a good, I don't know, 3, maybe 4 pets buried in the backyard. As kids, we didn't know any better. Parents didn't care, and so that's something that we would have to disclose. I know about it, because people are superstitious about things, right? And let's just say they start doing some type of renovations. Maybe they want to add a pool or something, and they start carving this out, and they see not just one, but they see multiple pets, right? And bones and all that stuff, right? And it comes back, and the neighbor says, well, yeah, they had pets. So they could put two and two, and that could be a position where they can say, I would have never bought this property if I knew there was animals buried back there. Yeah, again, I'm going way left field, right? But people are very sensitive to certain things, right? My opinion, because I know the nature of that, and if I ever decide if I'm in that position to do so, I would fully disclose it. What's so funny is now my parents have a couple pets, and the one that was the prior one ultimately passed away back in 2021. But that dog uh, started digging and found some bones there. And it's like, oh my God, that's one of our pets there. So it happens, right? So full disclaimer on that. Visual inspection duties. Licensees must still conduct a reasonable, competent, and diligent visual inspection of all access, 1 to 4 units, right? So if you're the listing agent or the buyer's agent in this position, then yes, you still need to do an audit, all right? You're not exempt from doing so. All right, so let's go into the real estate commissions and how commissions are set when they are earned, and how courts may split them, and how court forms of for your compensation works. All right, so the commission is established and earned. Commission is capped by the county. The court determines reasonable compensation, but cannot exceed local court rule maximum. As an example, Los Angeles County, the maximum percentage is what? 5%. Yeah. Except vacant land or exceptional circumstances. Orange County is 6% maximum. And again, this may be a little different now. I'm not sure. This presentation was done a while back, but just to get you kind of the base information, this is where we're at. Commission is also not to exceed the listing contract amount as well, which would be that 90-day. 3 conditions to earn compensation. The estate becomes liable for a listing broker's commission only when all 3 of the following occur, right? Because remember, the court is really the one appointed to help navigate the assets, right? And then the court then appoints the executor to be able to handle the day-to-day obligations, right? But they're still in position because they're the ones that ultimately have to pay or authorize, I should say, all of the deceased's obligations, taxes, debt, and responsibilities when it comes to whatever money is being earned from all of the assets that are being sold, as an example. So the actual sale, as sale is made, court confirmation, sale is confirmed by the court unless under the independent agreement, as we've mentioned, and consumption is. The sale is fully consumed, deed, transfer, purchase, price received. So most of us know about the National Association of Realtors settlement and probate court commission split, right? So this happened back in 2024 when the NAR settlement ended up happening. So without the MLS offer of compensation, because we know if you're the listing agent, we cannot put anything right on the MLS that says that the buyer's agent, even though the court says total of 5%, will be split 50-50, 2.5 for the listing side, 2.5. So this is kind of a disclaimer that allows the court to be able to kind of override certain things, right? And the risk of that confirmation. Without the MLS offer of compensation, a probate court judge may split the listing broker's commission and pay a portion to the buyer's broker, even when the listing broker is paid for selling side only, right? Because remember, the listing agreement doesn't have anything that says that the buyer's agent will get a certain percentage of the commission, right? Because this is where it all stemmed and started from, was from the lawsuit that happened, right? because the seller is like, why am I paying the buyer's agent a commission when they don't represent me? You represent me. I get that I'm paying you, but why am I paying the buyer's agent as an example, right? That's where it all kind of stemmed, right? So the listing agreements were all revamped and changed not to include cooperating compensation to anyone that brings us a ready, willing, and able buyer. That's where it all kind of stems. Now, how does it protect your commission, right? Well, from the form, there's a form called the PAPA, PAPA. The probate agreement purchase addendum includes a broker compensation agreement that, when signed by both agents, it's intended to supersede the probate code appointment. Pursuant to the full authority ensures the administrator or executor obtains the full authority, so court confirmation requires, including statutory commission splits, do not apply. Buyer broker use a signed buyer broker representation agreement, better known as the BRBC. Again, you still have to go through the motions if you represent the buyer, that you must have a buyer representation agreement, and you can still wish to say, I want to get 3%. Okay. But most agents that have a probate listing will already disclose that the maximum amount will be, 2.5%, right? So even though you'll submit a 3% asking for the court or the estate to grant you the 3%, most likely, in most cases, they won't. But who would be responsible to pay you the difference? The buyer. So if you submit a 3%, and they say, no, it's only going to be 2.5%, then your buyer would come in with the difference to pay you the full 3% that you're entitled to. So how does the PAPA form work? Two scenarios. Original buyer confirmed. The PA states that the seller broker and the buyer broker each receive payment per their own compensation agreement with their principal. This is intended to supersede probate code appointment, right? Both agents must sign the PAPA, page 2, for this provision to be in effect. Scenario number 2, original buyer is overbid. The original buyer broker waives all commission rights per the PAPA agreement. The listing broker should receive at least 50% of the commission on the original bid price. Any commission earned above that bid goes to the overbid buyer broker. Without the PAPA, the listing agent may receive a little as 1/4 of their anticipated commission. Okay. Commission cases. Licensee as a buyer. The estate is not liable for compensation where the listing or the selling broker is directly or indirectly the purchaser or has any financial interest in the purchase. Commission not ordered at hearing. If commission is not ordered on the court record at confirmation, the broker may request it in writing. Failure to be presented and asked at the hearing may result in the court declining to modify the order. Commission confirmed but unpaid. If escrow closes and the estate fails to pay, the broker becomes a creditor of the estate and may institute a proceeding for payment. Note, no commission is earned if the buyer defaults. The broker may not file a claim in this cases, right? So you go through the motions, the buyer doesn't perform, buyer releases all contingencies, because in probate, it's a very stringent process. They may ask you to release certain contingencies right off the bat because they don't want to waste time. They don't want to delay this. They want a ready, willing, and able buyer that is going to be able to close. But in those circumstances, if the buyer does fail and doesn't perform and breaches the contract, the agent unfortunately cannot go after compensation, even though the buyer released their contingencies. Broker compensation disputes. The probate court generally will not interpret commissions split disputes between cooperating brokers. They should be resolved through the Board of Association. So yeah, I mean, just like anything, if there's a dispute regarding compensation, commissions, and all that, we usually escalate it to a local hearing at the local board for dispute regarding some type of compensation. Usually, if we have a BRBC, right, then we can definitely take the buyers and say, hey, you know what, I'm owed a commission, but not when it comes to a probate. Submission of offers. All right, so here's kind of a rundown on the guide on how it works when you do happen to come across a property that is in a probate situation. All forms must be in writing. Use the car probate agreement, purchase addendums, title conveying, whether, but it's kind of all regular stuff, right? It's through the process that one, you need to be asking a lot of questions to the listing agent just so you're clear. Now, most probates have already a guide of what needs to be provided, so there's no waste of the time. Because if you don't follow the rules, what's going to happen, your offer will not be even considered. Okay? Because the courts are very concise in what they're requesting. The listing agent has to be in line with the court's instructions, and then that information is passed on the MLS and passed on counter offers. So that way the buyer's agent knows exactly, here's the list of instructions we're asking. And if you don't follow the rule, then we can put your offer aside. And then the buyer's agent is pissed because they haven't heard anything. Well, you didn't follow the rules. We said you needed X, Y, and Z, and you only have A, B. We didn't say for A and B, we said X, Y, and Z. So therefore, your offer was not considered. We ultimately accepted another offer, right? So they're very, very particular when it comes to stuff like this. So be mindful of how you navigate that if you're representing a buyer, because the buyer will be upset at you. Why did my offer not get considered, right? So be mindful about that. Who receives and who accepts? Submit the offer to the person representing or whoever is listed in the notice of sale. The estate attorney often reviews offers first, right? So it really depends on if it's court confirmation or not court confirmation, right? If we have court confirmation, it's going to be kind of like a regular sale. If it still needs to be approved by the court, then any and all has to still go through the proper channels, right? When you're offer. So it may not be something that happens immediately. This may be for several weeks or several months. The buyer has to understand it may be a little longer than your traditional sale. So I personally, encourage when I hear about probates, I ask, is this already approved, court confirmation or not court confirmation, right? Because that will tell me if it's going to be a long escrow or a short escrow, right? We want these deals to go as quick as possible, but also they may not have the proper authorization yet, and this may be the reason why it may take a little longer than your typical sale. When to submit, offers may be submitted anytime before the sale closes. All non-offers must be presented to the personal representative. When in doubt, submit. The safest course is always to present the offer, right? So again, do your due diligence and make sure that you also understand how the process works. And if you don't know, ask. Okay, we have a lot of people. I'm going to put Fred Howard on the spot because Fred Howard here in our office does a lot of probates. So he is my go-to when it comes to certain general questions that I have, because I'm not 100% all in all this. So I reach out to Fred, and he tremendously helps with answering some of the questions. Minimum price and deposit and timelines. Minimum price, it should be, again, the 90% rule. Full authority, private sales must be at least 90% of the appraised value, appraised within 1 year of confirmation. 10% is the typical deposit. Wait a minute, Simon. I thought it was up to 3%. Yeah, well, when it comes to these type of court probates, the minimum is 10%. So your buyer needs to be aware that it's not typically 3%. Many courts require a 10% deposit at confirmation, cashier's check, or certified checks. Local rules vary. No statewide mandate on this. 30 days to confirm. The personal representative must file for the court confirmation within 30 days of acceptance of an offer. If not, the buyer may petition the court. All right, we're going to go into the overbids now. How the overbids process works. And again, if anyone wants this presentation, please let me know. Just send me an email and I'll be more than happy to send you the full presentation as well. Okay, so minimum overbid formula. The first overbid must exceed the original bid by 10% of the first bid. So if you're thinking that you're going to just make a 2,000 above the asking price, they may not even consider it. They'll just stay with the original, right? But if it's at least 10% more than the original, right? So how do you do the math on something like this? So I make an offer of $1 million. What would the offer have to be considered an overbid? Yeah. Yeah. So 10% of $1 million is 100,000, right? So that would be the minimum. So if you submit an offer of $1,050,000 as an example, they may not even consider it. They'll say, well, we already have one there. It has to be, at least for your consideration to be considered or accepted, it has to be a minimum of 10% of what the original bid is in order for you to be considered. It's my understanding. Okay. 5% of the amount of the original bid exceeds 10,000. So an example, original bid is 100,000. 10% is $10,000 equals 1,000. So 5% equals 90,000, which equals 45. So the minimum overbid would be 105. So let me make sure I got this correct here. So 10% of the 10,000 of the originals. Okay. My apologies. So I understand. So whatever the overbid would be based on the amount that you're actually going over, then that's where the 10% comes into play. So if you look at the math, is the 10%, or excuse me, the $10,000 that you overbid, then that amount has to exceed the 10%. And that's where the 10,000 equals $1,000. Does that make sense? I think I misunderstood in navigating the conversation, and that goes over with the 5% rule. 90,000 equals 45. So the minimum overbid would be, in this case, 5,500, which so yeah, like the original bid is 5%. I'm just the 5% of the amount of the original bid exceeding the 10%. So it's a little complex. And that's where we definitely want to get some clarity in how all of the overbid works. So overbid acceptance, confirmation hearing, court confirms the sale. The court concludes overbid much like an auction. If the higher creditor offers and submits, the court cannot consider it unless the personal representative affirmatively enforce the court it is acceptable. Okay. And I still wanted to double check in how that works. I'll reach out to Fred and get clarity on this. And if anything, I can always update the slide too as well. So the Independent Administration Estate Act streamlines the estate administration by reducing court oversight, understanding its scope, and essential for every probate real estate licensee. So what does that mean? So the framework, right, is full authority, can sell, can exchange the property. No court supervision is needed. So when you hear someone say full authority, that basically means we're good to go. We can sell it as a traditional regular sale. Limited authority requires court approval. Cannot sell properly directly, right? We still got to go through the motions, and navigating cannot sell immediately. You would still have to go through the courts in order to make this work. Full authority, price, terms, and notice, no price restrictions, notice of proposed action, right to object, and then the commission by agreement. Okay. Kind of already some of the stuff that we talked about. Should the representative use or court confirmation? Factors favorably the process is typically faster. No overbid or court confirmation is required. The representative can agree to any terms and contingencies needed to close. Factors in favor of court confirmation: overbid at the confirmation hearing often increases the purchase price in the estate process. Court oversights may be provided additional protection from the estate. Determining the factors always what is in the best interest of the estate. The representative is not required to use the IAEA, even if the authority has been granted. Okay. And this is, I believe, the last presentation slide. So the key takeaways from California is know the code, right? The CPC governs price floors, confirmation timelines, notice requirements, and commission limitations. The local court rules and other layers always verify county specifics on maximums. The use in the right forms, obviously the forms that are used in order for you to be considered are the probate forms that are necessary for you to handle this particular process, and then protect your commission, pursue with the authority when possible. Buyer broker should always secure a signed buyer representation agreement. Treat it like just a regular sale. And then the disclosures, yes, they're exempt from the TDS and the SBQ, but in any no material fact, the estate would still have to provide these as part of the disclosures, right? Any material facts about the property needs to be involved, and it's okay as a buyer's agent to ask those questions. Hey, who's handling the estate? Well, it's one of the children, right? So then that's kind of an alert for you to already know, hey, they should know a little bit more. Let's dive in deep again into all of the documentation so we know exactly what the buyer's getting themselves into, right? And more so. And I'll leave it at this. Make sure that the buyer does their due diligence and does a thorough inspection, because a lot of listing agents will put that as an exempt that they don't know, and then that may be questionable, right? So we always want to make sure that our buyers do a thorough inspection, and that's roof, sewer, plumbing, general inspections, everything to satisfy themselves to the overall condition of the property. With that being said, that concludes our lecture. Any final thoughts before we close out? Yes.
I can say if the person who's handling it, the probate, has full authority, they can change and increase that commission amount. The last transaction I did with a probate, and the person who was handling it, because he knew me and he wanted me to represent that buyer,
yeah.
and he told me that I could go on and do the 3% commission. And so when Fred saw that, then Fred said, "No, Bernice, you can't do that. The maximum is 5%." And the gentleman came back. He said, "No, I have full authority. When you have full authority, you can't." And it was so. And I got the 3% commission.
There you go. Okay, good to know.
Full authority, they can increase that commission.
That's good to know. So under full authority, they basically treat it as a regular. You have the authorization and you can negotiate terms that are favorable or an advantage to. Okay, that makes sense. So, but that's not the case when it's not court confirmation. Yeah. Very cool. Awesome.
Simon.
All right, let me look through. Yes.
Hi, Susie. Just a quick comment, and right now I'm in escrow with a probate sale, but the listing agent told me that there's no court confirmation, meaning it's a normal sale. So, and there's an administrative executor on it. So that's what it comes down to. It's the easiest if it's no court confirmation, correct?
That's correct. Yes.
Yeah, that's just, it's going as a smooth, but she said the first 2 weeks we have to wait. Something about an announcement has to be made somewhere, like in the court or in the newspapers or something like that. So that's what we waited on.
So
Nothing came up.
Yeah, that's more. Oops. Did I just I think let me start over again. I just cut him off. Shame on Simon. But yeah, just to answer the question, when it comes to these type of situations, you always want to delegate it and navigate it to the attorneys, right? The attorneys will be the ones that'll give you most of the answers, right? And tell you, well, this is the way you're supposed to do it. Yeah, let me see if I can get back plugged in. I apologize. When I shut the presentation for some odd reason, it closed out the Zoom as well. You got to love technology, right?
No, we're here. We can see you.
Oh, you're still there. Oh
Yeah,
my
we're all
God.
here. I can see you and I can hear you. No, it's all good.
I don't see you guys. That's so funny.
Thank you.
Oh God. All right. So thank you. I just don't see you guys on Zoom. I don't know where you guys are at here. Let me stop sharing here, but I don't see you. But anyhow, well, I'm glad you at least can hear me. So as I was mentioning, right, it's always best that you navigate the questions with people that have done the probates, right? So check in with your office and see what agents have done probates and pick their brain and ask them. Also, I would encourage all of you is tap into at least 3 attorneys and ask them, hey, I want to know a little bit more of how the process works. Are you willing to guide us and maybe come in and do a presentation at our offices, right? Obviously, you talk to leadership and make sure that they're vented and they're good to go before you just randomly pick someone, right? Because we want to have good quality individuals. Mark on the Zoom mentioned Paul Horn. Paul Horn is definitely one of the seasoned, experienced veterans. His office is in the Cerritos city, and his wealth of knowledge. You can follow him on, I think he has a lot of videos on YouTube. If you just type in Paul Hearns or go to his website, and I believe he has a lot of resources and information. Educate yourself is important, right? Because probate is constantly changing on a regular basis. So with that, if you're interested in getting a copy of the presentation, just send me an email. I'll go ahead and send you a PDF of the presentation. All right, that concludes. I appreciate you all who stuck around, and I'll see you in the next contract class. Thanks, everyone.
Thank you. This was really informative. Thank you, Simon.
Thanks,
Thank you. Thank you. I appreciate it.
Thank you, Simon.
All right. Thank you. Goodbye.
Bye-bye. Bye-bye.